Okay, I think we have to go ahead and get started. One of our panelists has to leave promptly around 5 o'clock, so we don't want to get things too pressed. So welcome to a panel discussion on First Amendment litigation. This event is part of a series that are happening this week, exploring the intersection of the law and humanities. On Thursday, there'll be a keynote address by the historian Vernon Burton, who's back there. You can all say hello. He's going to talk about the First Amendment and Lincoln's constitutional legacy. And on Friday, there will be a roundtable discussion in honor of Dr. Burton with a group of historians who are all his former students. These are all part of events this week sponsored by Clemson alum Chris Loebsack and his firm, Loebsack and Brownlee. I'd like to thank them for sponsoring these events, as well as the College of Arts and Humanities and the Honors College for agreeing to host us in the Great Hall here. The focus of events this week is on the First Amendment, chosen partly to correspond with the 250th anniversary of the Declaration of Independence. Although it's notable that Madison only wrote the Bill of Rights grudgingly, and it wasn't ratified until 15 years after 1776, the First Amendment is foundational to U.S. democratic governance, both procedurally and historically. It's hard to imagine democratic governance functioning in this country without it. Even so, I don't think it's just recency bias on my part to note that the First Amendment protections have come under new and serious strain in the 21st century. There are a variety of interrelated reasons we could point to for that: political uncertainty and polarization, legislative sclerosis, the emergence of algorithmic social media and so-called artificial intelligence, and the fragmentation and weakening of traditional news media. Whatever the mix of causes, the newly challenging terrain in our changing political, social, and media landscapes make the actual practice of First Amendment law an increasingly crucial bulwark to protect core democratic freedoms in this country. So for that reason, I'm thrilled that we'll be hearing today from two panelists directly involved in litigating First Amendment cases in the courts. First up will be Gabe Walters, attorney with the Foundation for Individual Rights and Expression, sometimes called FIRE. You see this in lots of media discussions over the last several years. Walters has a BA from the University of Mary Washington and a JD from the University of Virginia, and he has extensive experience litigating First Amendment cases, including cases involving academic freedom, the most important one. Our second speaker will be Claire Norins. Claire Norins is a clinical associate professor and director of the University of Georgia School of Law's First Amendment Clinic. She received her BA, MSW, and JD at the University of North Carolina. Norins was a co-recipient of the 2021 National Clinical Legal Education Association's Award for Excellence in a Public Interest Case, in recognition of her work on behalf of women retaliated against for speaking out about medical abuse they experienced in ICE's Irwin County Detention Center in Georgia. And finally, our moderator and respondent, Michael Gregory, Assistant Professor of Philosophy here at Clemson. Gregory has a BA from Columbia International University, an MA from the University of South Carolina, and a PhD from the University of Groningen in the Netherlands. Gregory also directs the Philosophy Department's Law, Liberty, and Justice pre-law program. Please join me in welcoming our speakers for today.
Thank you. Again, my name is Gabe Walters. I'm going to do my best to project. I love to see this standing room audience. Thank you so much for coming out on a late Tuesday afternoon to spend your time with us and hear about the First Amendment. I'm going to do what I can to move this along quickly because I know you'll probably have a lot of questions for us, and I want to make sure we have time to get to those. All right. I would like to give sort of a broad 50,000 feet view of the free speech clause of the First Amendment. There is a century of free speech jurisprudence, so I can't cover everything, of course. We're going to do a crash course, and I'm going to talk about a few of our cases at FIRE, and then I'll turn it over to Claire to talk about the great work that she does at the University of Georgia with her clinic. This is the text of the First Amendment. Congress shall make no law, ... abridging the freedom of speech. Congress shall make no law seems to be pretty absolute, but then what does abridging mean, and what does the freedom of speech mean, right? What is the scope and the content of this right that we all enjoy? What does it mean that it applies to Congress? I'll skip that question and let you know that it has been applied to the states through jurisprudence over the years, but that was not settled at the time of the founding. In fact, not a lot of free speech law was settled at the time of the founding. It's because of cases since the 1920s with the first Red Scare that we have free speech law in the federal courts really at all. I think that maybe the idea was that the state courts would enforce federal rights, although that didn't happen too much, or it happened inconsistently, and thankfully we've had now what is called the free speech century behind us. So a lot of the law that we have in the First Amendment comes from throughout that century, including and especially the 1960s, as a result of the civil rights movement and other movements for social justice throughout American history. So what does the First Amendment protect? Here we have a picture of someone burning an American flag. This is a recent photo from, I believe, a pro-Palestine rally, if I'm not mistaken. I borrowed these slides from one of my colleagues, so don't quote me on that. This is a quote from Texas v. Johnson, the 1989 U.S. Supreme Court case that announces the bedrock principle of First Amendment law. Pulling from prior cases, of course, if there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. Obviously, the burning of an American flag is extraordinarily offensive to a lot of people. Again, from Texas v. Johnson, the American flag, throughout more than 200 years of our history, has come to be the visible symbol embodying our nation. It does not represent the views of any particular political party, and it does not represent any particular political philosophy. The flag is not simply another idea or point of view competing for recognition in the marketplace of ideas. I'm going to stop reading that because it goes over this slide, but you get the point. The flag is important. Burning it is offensive to a lot of people, and yet we cannot ban the burning of the American flag simply because people hate that idea. The First Amendment is often said to protect the idea that we hate, right? So, I'm going to show some pictures here. Here we have a Klansman in the middle of a Black Lives Matter rally. Here we have a confrontation on a campus, somebody doing the Sig Heil and another person flicking them off. Fuck your shitty town, bitches, in a letter to a city council person. From the river to the sea, Palestine will be free. What these photos demonstrate, I think, is that the First Amendment is a living document. There are hard cases out there. It protects a wide variety of speech, and sometimes very emotionally charged, very in-your-face speech that has the potential to spill into violence, right? In some of these examples, I think I would have preferred in my heart of hearts that security step in and add some distance between protester and counter-protester. But all of these are protected political messages. All of these are contested viewpoints at the heart of what the First Amendment protects, the freedom of speech, regardless of the point of view being expressed. Here we have photographs from a student, Ramesha Ozturk, being swept into an unmarked van by ICE officers who did not identify themselves. They did that because she published an op-ed calling for divestment from Israel by American institutions. That's all that she did. That's all that she's alleged to have done. She was in the country legally. She was a grad student, if I'm not mistaken, here on a student visa. She spoke in an op-ed expressing a political opinion, and for that, masked agents put her in a van and whisked her away to a prison in Louisiana, if I'm not mistaken, several states away from her home and her family, and took several days to even identify where she was. Marco Rubio, the Secretary of State, says that he has authority to do that under two provisions of the INA, the Immigration and Nationality Act. I'm happy to say that FIRE has drafted an amicus brief in support of Ramesha Ozturk and has also sued Marco Rubio on behalf of the student newspaper Stanford Daily, as well as some other plaintiffs, to try and declare those provisions of the INA unconstitutional because it gives the Secretary of State essentially unfettered discretion to determine when somebody, anybody, here legally but not a citizen, is a threat to the national security interests of the United States. And so long as he can do that on the basis of nothing but their mere political speech, that is quite obviously unconstitutional, and we have high hopes that the court will see it that way as well, although that case is proceeding to summary judgment and is not yet resolved. Here are some more pictures from recent protests. This one's a little bit different. This is obviously a political message, but it is graffitied onto a building. That is not itself protected speech. Similarly, encampments can be protected speech if they're done in accordance with content neutral and viewpoint neutral time, place, or manner restrictions on campus. A lot of campuses reacted to student encampments in recent years by changing their campus speech policies to prohibit encampments, including overnight encampments. Here is a student who, I believe this was on, I can't remember where he said this actually. I think it was on, what's the geo-fenced social media thing that you can post comments to, like say Clemson, you're on the Clemson site and you can post something and zip zap, something like Yik Yak, thank you. Thank you for saving me there. If I'm not mistaken, this was posted on Yik Yak. There are several examples of similar speech that have been posted to Yik Yak, so I may be confusing the source of this particular statement. But you get a lot of this like anti-Semitism posted on sites like that. And here he says, if I see another Jew on campus, I will stab you and slit your throat. That is, I think, probably objectively threatening, right? Anybody who reads that would probably fear this person, reasonably so. But then the question is that protected speech? And we'll come back to the standard for that. Here's some more examples from recent campus controversies. Obviously, occupying buildings and causing property damage is not speech by itself, even when it's accompanied by speech. So these are not examples of protected speech, even though politically motivated. And then we have here violence erupting. I believe this was at an encampment, and I can't remember which campus this comes from. But property destruction, graffiti, occupying buildings, these are going to be examples of non-protected speech. Violence, of course, not protected speech. So let's talk about what is protected and what is not protected. Generally speaking, speech is protected unless it isn't. Well, that's a tautology, right? What does that mean? In America, under our First Amendment jurisprudence, we take what's called a categorical approach to exemptions from the First Amendment's coverage. So we have a set of limited, narrowly defined categories of speech that are exempted from the First Amendment's protection and coverage. That includes true threats. And a true threat is a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. So let's go back to that statement that we saw earlier. If this is just sort of thrown out on the internet, not targeted to a particular person, it maybe doesn't fit that definition of true threat. But if this is, Yik Yak and it's targeted to a particular campus, maybe that kind of starts to cross the line. What I want to convey to you is that these are hard calls to make, and some of these examples are very much contested as to whether they're protected or not. And we do a lot of line drawing in First Amendment law. And so the question is, does this cross the line? right, from protected speech to unprotected speech. There's a 2023 case, Counterman versus Colorado, which you see at the bottom there, which finally settled the question of what is the mental state that a speaker has to have in order to make what the law calls a true threat that's unprotected by the First Amendment. So do I have to speak negligently if I'm the speaker and I say something like, if the president sends me overseas, right? If he tries to put a gun in my hands, the president will be the first person I get in my sights. That's a paraphrased example from the leading case on true threats, Watts versus United States, from 1969, if I remember correctly. A Vietnam War protester, at a rally where they were burning draft cards, said he was going to shoot LBJ if LBJ tried to put a gun in his hand and make him kill his black brothers. He was convicted of threatening the life of the president because the court held, the trial court held that an objective observer of that situation, familiar with the facts, would reasonably believe that he had threatened the president's life. So that's what's called an objective standard for the mental state of the speaker. The Supreme Court reversed and said, we have to distinguish what is hyperbolic and even violent, rude, intemperate, political hyperbole from what is actually a true threat. So that's where this category of true threat comes from. There was another case in 2003, Virginia versus Black, which involved burning crosses on people's yards, or really anywhere, if I remember correctly. The problem with the statute was that the act of burning a cross was taken as prima facie evidence. That means rebuttable but presumptive evidence of an intent to make a threat, the mere act of burning a cross. Now, burning a cross can be threatening. It can be intended as threatening, but merely burning a cross doesn't necessarily prove that you actually intended to make a threat. And so that's what the Supreme Court so held. But still, from 2003 to 2023, in this period between Virginia versus Black and Counterman versus Colorado, the appellate courts below the US Supreme Court differed on what is the requisite mental state needed to convict somebody for making a true threat. Most of the circuit courts said you just have to speak negligently. Basically, you should know that what your statement is, what you say is threatening, and people are going to take it that way. Even if you don't actually hold that view in your own mind, you're subject to conviction for saying something that is objectively threatening. Finally, and then a minority of the appellate courts said, no, you actually have to intend to make a threat. You have to know what you're saying and know how it's going to be perceived, or you have to have the purpose of making a threat, or maybe you have to consider in your own mind subjectively that the person you're speaking to would interpret it as a threat, and you disregard the risk of their interpretation, and you go ahead and say it anyway. And that's the standard that the Supreme Court settled on finally in Counterman versus Colorado, that reckless disregard standard. And the reason they did that is because speech that's at the margins of political or social acceptability needs breathing space so that we don't over-censor speech that is potentially harmful but not intended to be threatening. And that's a standard that's borrowed from defamation law too, which is one of the other categories of unprotected speech. And here's a list. So we know the First Amendment is not absolute, right? We know there are these categories of speech that are not protected. They include obscenity, which has a complicated multi-factor test. The bottom line there is that most pornography that's widely accessible is not unprotected. It's protected speech as to adults and their right to access it. Child pornography is not protected speech. Incitement is not itself a true threat, but riling people up to go do some unlawful act, right? So the test for incitement is if a speaker has the purpose of inciting an imminent act of lawlessness that is likely to occur. So you have to have the purpose, you have to have the likelihood, and you have to have the imminence. And if those three conditions are met, then you cross the line from protected speech into unprotected speech. If any one of those conditions is not met, then you don't cross the line. One of the most famous recent examples of the debate of whether something is incitement is Donald Trump's January 6th, 2021 speech to the crowd at the Ellipse that then marched on the Capitol, more or less after he finished speaking. There are First Amendment scholars and activists and lawyers who look at that and come to very different conclusions about whether his speech crosses the line from protected speech to unprotected incitement. Some say he had no intention. Some say the likelihood wasn't there. And some say the imminence wasn't met. And some even say because the rioters had to walk several blocks from the Ellipse to the Capitol, that the imminence standard wasn't met. I don't know about that last part, but my boss would disagree with me on that. The point is, these are tough questions. We talked about true threats. Discriminatory harassment is not protected. I said something about defamation. Fraud is not protected. If you lie and you get a material benefit out of it, you've defrauded somebody, you may have done that via speech, but that's not protected speech. And then there's another category called speech integral to criminal conduct. So for example, a criminal conspiracy is entered into through speech, right? I say, hey, do you want to go rob a bank with me? You say, yeah, let's go rob a bank. That speech, even if we don't ultimately rob the bank, so long as we take some material act in furtherance of robbing the bank, like buying, I don't know, bolt cutters so we can break in at night, I don't know, whatever, that speech is not protected speech. It can be used as evidence of the conspiracy that we entered into. Brandenburg versus Ohio is the 1969 case where the incitement standard that I told you comes from. Before Brandenburg, there was the clear and present danger test, which you might have heard that phrase before. Brandenburg says, no, clear and present danger isn't speech protective enough. We're going to go further. We're going to have that three-part test of purpose, likelihood, and imminence. This was a Klan rally, and the speaker said, if our president, our Congress, our Supreme Court continues to suppress the white Caucasian race, it's possible that there might have to be some revengeance taken. He says that to a large crowd of Klansmen. They do nothing immediately upon hearing that, and they were just like in a field somewhere, right? So there you have the definition of incitement that I went over earlier. I'm not going to repeat that. So just some broad takeaways on the exceptions to the First Amendment. Violence is not protected speech. First Amendment exceptions are few, narrow, and carefully defined to provide that breathing space for speech that's inexact, rude, intemperate, etc. And to protect freedom of expression, our position at FIRE is that the exceptions to the First Amendment must remain few, narrow, and carefully defined. And so we're interested in holding the line where it is presently drawn, for the most part, between what is protected and what is unprotected. But that doesn't mean that we're powerless to hateful speakers, right? Because the same speech rights that they have, we all also have. We're in favor of rules that are content neutral and viewpoint neutral and equally applicable to everybody, regardless of what their viewpoint is. So there are ways that we can respond to hateful speakers. We can deny them our attention. We can protest them. We can show solidarity and strengthen numbers. A really great example I like from that perspective, everybody remembers what happened in Charlottesville, Virginia in 2017, including by organizer Richard Spencer here. He was directly involved. They tried it again a week later. A lot of people don't remember this because it didn't get the same amount of attention, although it did get some media attention. A week later, they tried it again in Boston, and it failed spectacularly because counter-protesters flooded the streets of Boston in a show of unity and counter-protest, and just drowned out their message. So that's one. In that example, that was an effective use of solidarity and strength in numbers. Humor, you can mock somebody who has a stupid, hateful view. That's the thing that they hate most of all, in my experience. If you attend a lecture, at a university, say, somebody you don't like is coming to speak, you can ask sharp questions, you can challenge their viewpoints, and so on. I always tend to think that if somebody hates me or wants to do me harm, that it benefits me for them to express that and for me to know that, right? Rather than to drive their view underground where it festers and boils and eventually explodes into an actual act of violence. If somebody says, you know, that they want to do me harm, maybe I can see them coming, right? All right. Unfortunately, the Justice Marshall quote is cut off there. But he was a leading advocate on the court for the freedom of speech. A lot of the free speech precedent that we have comes from American movements for social change and social justice, including the civil rights movement, the women's suffrage movement. Free speech jurisprudence was birthed in the 20s and 30s because of the first Red Scare. We have a lot of academic freedom case law coming out of the second Red Scare with loyalty oaths and other anti-communist measures. Free speech is a radical concept. We exchange ideas, not violence. Unfortunately, we do both in America. There are critics of our First Amendment jurisprudence where it stands today, of course. One of the more prominent ones is the leading feminist scholar Catherine McKinnon. She writes in her book, The Free Speech Century, that once a defense of the powerless, the First Amendment has become a sword for authoritarians, racists and misogynists, Nazis and Klansmen, pornographers and corporations buying elections. And our response, of course, is the First Amendment protects all of us, but only if we stand up and fight for it, because rights don't vindicate themselves. And so that's part of what we do by coming to events like this and talking to you, is to help reinforce the idea that the same speech rights that apply to Nazis and Klansmen apply to you as well. And there's an example of this in Gay and Lesbian Students Association versus Ghosn from the 8th Circuit in 1988. This was a student association that was defunded because of its viewpoint. Once having decided to fund student organizations, the university is bound by the First Amendment to act without regard to the content of the ideas being expressed. So that group had its funding restored. What about hate speech? We hear this a lot, right? I support free speech, but hate speech isn't free speech. But much of what we might call hate speech is actually protected by the First Amendment, unless it falls within one of those categories that I mentioned earlier, like incitement to imminent violence or a true threat. And there are good reasons for this, I think. First, there's no agreed upon definition of what is hate speech. During the Biden administration, one of my friends said to me this phrase, almost word by word, like hate speech isn't free speech. And I said, I hear you, and you're my friend, and I know your values, and I know my values, and I think that you and I might be able to create, if we had enough time, an exhaustive list of the ideas and words that we don't want to hear ever again, right? And you and I together could probably make that list. But Donald Trump could be president again. Again, this was during the Biden administration. And Donald Trump thinks that Black Lives Matter is hate speech. And do we really want to give the government, any government, the power to define for itself what it considers to be hate speech? Because the political winds shift. And the list that I create and you create, is not going to be tomorrow's list. So we think it's better to take that power out of the hands of the state, to draw the lines that are currently drawn at viewpoint neutrality and content neutrality, and enforce the law as it is so that it benefits all of us. Time. Okay. I can sort of wrap it up. Just really quickly, do I have any minutes at all?
Maybe 1 minute to wrap up?
Sure. Just some current fire cases. Okay. We are representing a group of students at West Texas A&M University who want to put on a drag show. The president of the university said that it was offensive to women. He said, I wouldn't allow white students to put on a blackface show, and that's essentially what drag is, in his opinion. I disagree with him on that for what it's worth, but we're currently fighting that case tooth and nail at the Fifth Circuit. We represented a conservative group who wanted to put up anti-communist posters on their campus at a California school, and the school banished them to a so-called free speech kiosk that was at a remote part of campus. Campus administrators actually tore down their posters from the interior bulletin boards where students were allowed to post, but not them because they had the wrong view. And I will stop there. We'll save the questions for the end. Thank you so much.
Hello, everyone. Thank you so much for being here. It's really great to see a full room, and thanks to Gabe for giving the world's fastest sort of 411 on what is the First Amendment. So my name is Claire Norins. I direct the First Amendment Clinic at the University of Georgia School of Law. And our mission is to defend and advance expressive freedoms. So that would include speech, press, the right to assemble, the right to petition the government for grievances. And so I work with law students at UGA to litigate cases, mostly in federal court, but sometimes in state court, where we are protecting people's free speech rights and trying to get them compensation when they've been retaliated against for exercising their free speech rights. Gabe talked a lot about the government can't discriminate against people based on their viewpoint, which is a really core tenet of what the First Amendment protects, because, as Gabe was saying, we all have the freedom to think and say and feel whatever we want, as long as we are not, encroaching into those areas of unprotected speech like incitement or defamation. Beyond that, we have freedom of thought, freedom of self-determination. And the First Amendment protects that, because if we allow the government to determine what we can think and say and feel, we're not going to be free, and also it's going to change depending on who's running the government, right? So no viewpoint discrimination is just sort of the building block of First Amendment rights. Another really core function that the First Amendment fulfills is it protects our right to criticize our government, to criticize government officials. Critical speech about state, local, and federal agencies and actors is what we often refer to as sort of the highest rung of First Amendment protected speech. It's core political speech. And so that's another big bucket. You have no viewpoint discrimination, and you can criticize your government officials. And so I want to talk about two cases that our clinic is working on in the you do have the right to criticize government officials bucket. So one of the ways we see people's First Amendment rights being transgressed when they criticize government officials is that they will often experience what we call retaliatory arrest or retaliatory prosecution, or in the case that David was mentioning in my introduction, retaliatory deportation. And so there are First Amendment claims that can be brought in those situations where the retaliation is based on the person's speech that was critical of the government. So right now, and I can talk about this because it's publicly filed and we're publicly litigating it, we represent a woman in South Georgia who has kind of a running feud with her local sheriff, who, depending on your perspective, may not be a very good actor. He might even be called a bad actor. And she likes to call him out constantly on social media. And she, at one point, crossed the line from just posting it on her social media to actually texting him some of her thoughts. And it was his personal cell phone, but it's a number he's published all over the internet. telling everybody in the county, this is my number, you know, feel free to call me, I want to hear from my constituents. So it's really not his personal number. He's made it his sort of official number. And he didn't like this message, which stated, among other things, that she planned to start a recall action to get him unseated from office. And so he had his sheriff's office investigate her and charge her with harassing communications, and they actually got a warrant for her arrest. And fortunately, she works out of state. She's not in Georgia all the time. And so she was out of state. She learned about this warrant, and she got a lawyer, and the lawyer got the warrant recalled because she was engaging in political speech. It was crude. She, you know, called him a POS. She used some other sort of, you know, not the most polite language, but it was all her opinion about how he was performing his duties as sheriff and her thoughts on it and what she planned to do about it. And that is all protected. She didn't physically threaten him. She didn't say anything violent. She said, I'm going to exercise my First Amendment right to redress the government for grievances, which includes initiating a recall against you. And so now that the warrant has been recalled by the magistrate court, we have a federal lawsuit for her with just one claim in it. It's just a First Amendment retaliation claim. And so tomorrow I'm going down to Waynesboro, Georgia to depose this sheriff and taking students and junior attorneys with me who will be deposing some of the other officers from the sheriff's department. So that's an example of the kinds of things that our clinic works on. So also in the you get to criticize the government bucket, you often have government officials who've been criticized suing their criticizers for defamation. And a lot of times those cases are what you might call meritless because you have the right to criticize your public officials, and it's not defamatory so long as you are just expressing your opinion or saying true things about them, even if those true things are unflattering. And so when a public official brings a defamation case, the person who's being sued for defamation, in Georgia at least, has a defense called an anti-SLAPP defense. And SLAPP stands for Strategic Litigation Against Public Participation. And what that refers to is lawsuits that are not really about you defamed me. They're about, I don't want you to keep talking about me because I don't like what you're saying. And so maybe if I sue you, and then you have to get a lawyer, and then you have to spend a bunch of money to defend yourself in this lawsuit and worry about, are you going to have to pay me damages? Maybe you'll decide it's not worth it to exercise your First Amendment rights, and you will stop talking. And other people will see that happening to you, and they will also stop talking. And so that's what we call chill. So another thing that the First Amendment really protects against, or exists to protect against, is chilled speech. So in this bucket, the defamation case where you have an anti-SLAPP defense, we represent a very engaged gentleman in a county in Georgia who, recall is just really popular right now in Georgia. He was part of a recall action against a county commissioner. And the county commissioner challenged the recall, and the recall did not move forward. But then the commissioner has now tried to sue everybody who was involved in the recall action, including our client. And so our client, had posted some stuff on social media about this commissioner that the commissioner now says is defamatory. And we say, no, it's not defamatory, it's his opinion, or it's true. And truth is always a perfect defense to defamation. And so we've brought this anti-SLAPP defense where we're trying to get the case thrown out before it can really even go much further than the complaint having been filed, so that our dear client doesn't have to go through the pain of litigating it only to win at the end and have the court hold it was his protected speech. We want to short circuit all that and get it thrown out sooner. And so we have a hearing later this month where a student will be arguing that anti-SLAPP motion to throw out this defamation complaint. So that's another sort of bucket of the kinds of cases that we do. So we've talked about no viewpoint discrimination. We've talked about the right to criticize government officials. Another big area right now of First Amendment rights is the right to record. Are y'all familiar with the right to record? So this right applies to everyone. We all have it. We all have the right to record public government officials doing their job in public. So this comes up a lot with people recording the police. And you do have a First Amendment right. The Supreme Court has not yet recognized it, but a majority of the circuit courts of appeals, which are the federal courts just below the Supreme Court, a majority of those 11 circuits have recognized the right to record. And this is important to us as citizens, to be able to record things and post them and share them. It's a way to, share information, let people know what's happening in your community. It's also a really important form of news gathering. So an example of a right to record case that our clinic worked on, that's over now, it happened last fall, but was on behalf of the Spanish language journalist Mario Guevara. Did anybody read about him? This was a national case. So Mario Guevara, he had been in the United States for over 20 years, and he was a journalist by profession. He had started his own media company in the last couple of years, and what he would do is he would go around the metro Atlanta area, and he would film ICE raids or other law enforcement action happening in that area, and then he would live stream it or post it on his Facebook page, and he was a huge source of news for the local Latino community. And he was very connected to that community, and so he would get tips, and he would go before any of the other news agencies were there. And it was instantaneous because he was just live streaming it. He wasn't taking it back and editing it and then posting it. And so his media company grew, and he had like over 700,000 followers on his Facebook page. And local law enforcement and ICE did not appreciate that he was filming them. And so he got arrested at a No Kings protest back in June of 2025 on really bogus charges. He was there in his capacity as a reporter covering the protest, and he got arrested for stepping off the sidewalk into the street. And that charge got dismissed, but because he was in custody, ICE put a hold on him because he was here on an expired visa. And he never got out of ICE custody. But what our case was about is that we were challenging his custody because it was purely based on his having exercised his right to record. The government was arguing he's a danger to the community because he records and live streams and posts these videos and images of law enforcement carrying out their duties in public. I mean, he wasn't going into buildings, he wasn't interfering, he was mostly sitting in his car or driving around in his car or maybe standing on a public sidewalk recording what was in plain view. And the government argued, and they didn't make any bones about it. I mean, they were really clear that his recording was why he was a danger to the community and why he needed to be continued to be held in custody. And we had a federal habeas case for him trying to get him out, and he unfortunately got deported before our habeas claim was ever even ruled on. And our clinic certainly did not do this alone. We were working with the National ACLU and the Georgia ACLU and his immigration attorneys. It was a big team effort. But he was the first journalist, and maybe even the only journalist to date, to be held in this country, detained by the government in this country because he was exercising his right to record, because he was engaging in news gathering. And that is extremely chilling, not just for people who are undocumented and at risk of deportation, but really for any journalist. And we see that continuing. We see the press being persecuted. There's so many examples, but one very recent example is the prosecution of journalist Don Lemon and Georgia Fort. Are you familiar with this situation? Some of you? Okay. So do you know who Don Lemon is from CNN? He's now an independent journalist, and Georgia Fort is just a local independent journalist in Minnesota. But they filmed a protest that took place in a church in St. Paul, Minnesota, where the protesters went into the church while there was a service going on, and they did disrupt the service. And the reason they did that is because the pastor speaking at that service is an ICE field director, or interim ICE field director. And this was during the sort of siege on Minnesota, right, that just only recently kind of abated, where ICE was, very present and not necessarily in a good way. And so Don Lemon and Georgia Fort are there as journalists. They're covering what is a newsworthy event. It's a protest. It's about issues of public concern. They didn't plan it. They didn't facilitate it, but they are there covering it and reporting on it and trying to interview people, including the pastor who didn't want to talk to them. And now they are facing charges for violating the FACE Act, which is a law that is mostly intended to protect entrances and exits to abortion clinics, but it also has a provision about not disrupting religious services. And so they are now having to defend against a charge that is, not going away. It's not been thrown out because they were merely engaging in news gathering. And so talk about chill. I mean, that's very chilling when you think about we rely on the media, we rely on the press to go out and be out there and to document things and to digest things for us and tell us. We don't have time to do all that ourselves. We need to be informed, and we need the press to do that. And I could give you, and so could Gabe, a litany of examples of how freedom of the press is under attack right now. But it's very dire, and we all need to be paying attention to it. So if you care about these issues, if you want to work on First Amendment freedoms, if you have issues with authority, First Amendment law is a really good field to go into. You can go to a law school like UGA, or there's many other law schools around the country that have First Amendment clinics now where students are getting to work on these cases as students. And it's a really cool thing to be part of, and it's also just really great skill building. Whether you want to do First Amendment forever or not, you learn how to develop a case, how to investigate a case, how to come up with your legal theory of the case, how to frame it in a complaint, how to do discovery, where you do depositions and you get documents and you try to find out everything you can about what went on in your case, and then you write briefs about it and argue it in court. And that is very applicable to many different areas of the law, not just First Amendment. But it's really fun to do it with First Amendment. So I encourage you all to think about, if you do go to law school, looking for a law school that has an active First Amendment clinic or other sort of civil rights litigation clinic. So I think now we'll take questions. Yeah? Okay, sure.
You just want to go in and I'll take questions, yeah. Real quick, I don't want to take up too much time. A lot of you know me and know that I could talk for an hour and a half about bullshit probably, but I just want to bring up two limitations to the First Amendment and reasons why First Amendment jurisprudence is so exciting and dire in our current moment. The first is the marketplace analogy that was made famous by Justice Holmes in 1919. And he was basically translating John Stuart Mill into sort of contemporary market language, and saying that the First Amendment was about protecting a kind of free market of ideas, that we have a kind of free market in which your ideas and my ideas can conflict, and the best way to find the truth is by allowing that conflict to happen. Now, one of the limitations of this, of course, is that free markets are notoriously unjust, right? the court for the last century has decided that the best way to keep our market free is from content and viewpoint neutrality. But there's a question, an open question, about whether neutrality is the correct response to try and keep a market free so that you and me can participate in that market in equal measure. Yeah, Gabe, you talked about the ability to speak back against problematic speech. But of course, the power to speak back and your power to speak is only effective if me and you are on the same ground, right? And so one question that we have to ask ourselves when thinking about the free marketplace of ideas is whether this marketplace is actually free, right? Whether we're actually living in a place in which me and you can engage in speech acts in the same way at the same level. Another clear limitation of the First Amendment in our current era is that more and more often, and so the first one was about the last 100 years of jurisprudence, and this is about the text of the actual First Amendment. For the past 20, 30 years, it's been very clear that we have non-state intermediaries that are functioning as censoring bodies on our speech. I'm speaking, of course, of like social media platforms, right? One problematic limitation of the First Amendment is, of course, that it's meant to limit the state or the Congress against people who want to speak against the state. And yet, we see in our contemporary era that a lot of censorship and a lot of difficult First Amendment questions are arising not between the state and the citizen, but actually between private actors. And the question is what do we do about that? Can the First Amendment give us any resources to say anything about that in our current era, where more and more of the marketplace of ideas is being given or privatized by these large tech companies that, at least in our country, run completely unregulated, right? It's different in Europe, where they have laws. And so here these completely unregulated bodies continue to challenge our ability to speak and hear each other. Whether the First Amendment has the ability to address that is an open question. Many people suggest that it doesn't have the kind of resources that we would want it to have in a contemporary marketplace of ideas. So these are the two biggest limitations. Of course, I'm a philosopher, so I have these big sort of ideas that go beyond actual doctrine. But the First Amendment as an idea, and especially as an idea as it exists in the US, we should understand has limitations about the kinds of things that it can address, and those limitations aren't all good, right? Some of them are good and some of them are bad. So that's just what I wanted to say. Now we can either open it up to questions, if you guys have any. The questions can be about the substance of the First Amendment. It can be about law school. It can be about contemporary issues. It can be about anything that you guys feel like you want to talk about.
If I could, before we jump into questions, or Delaus, I should say. Can I offer a response to the critique?
Sure, of course.
And Claire, feel free to jump in, of course. I mean, you're absolutely right. The marketplace of ideas is a quote from Holmes, and he's borrowing from Mill, the famous essay on liberty, that if you I think there are a lot of pre-law and poli-sci students in the room, right? So you've probably read it. If you haven't read it, you should read it. Mill is one of the foundational philosophical thinkers behind the intellectual history of our free speech jurisprudence in this country. In addition to Madison, Holmes, Brandeis, Learned Hand, Alexander Michael John. You absolutely should read John Stuart Mill if you want to understand First Amendment law. That being said, Holmes's invocation of the marketplace of ideas is a metaphor, and it's an imperfect metaphor, right? He is envisioning a process by which idea hits counter-idea, thesis hits antithesis, and there is this almost dialectical process toward truth-finding. And that he supports the freedom of speech precisely because of its ability to take steps toward truth. And so the speech that we value or should value is the speech that brings us closer to the truth, whatever that is. Of course, we live in a post-Foucault world where the concept of truth is itself contested. But that's just, I think truth-seeking is just one of many purposes or potential purposes behind the freedom of speech as a concept or as a value that we should hold, right? There's also authentic self-expression, right? Free speech includes the ability for ourselves to speak as ourselves, for ourselves, to say what we really believe, right? To identify as humans and as citizens in a polity. There's the ability to criticize government in a system of democratic self-government. That doesn't necessarily have anything to do with truth-seeking, right? We can decouple those concepts, especially as our politics continues to pursue this sort of post-truth environment in a way that I don't think Foucault himself would have intended. So I just want to say there are multiple purposes behind the freedom of speech, but you're absolutely correct that it's an unequal market. Power is distributed unevenly. There are barriers to entry, if you want to borrow another economic term, right? So those are very important critiques of the marketplace as a concept and our political and social reality.
Yeah, thanks. Yeah, and neutrality often covers up these sorts of things, despite it might still being our best option.
Well, I think neutrality in terms of content neutrality and viewpoint neutrality is the best ensurer of equality with respect to rights-based and rules-based law, right? It might not produce the best social outcomes or outcomes that you or I might like and might want to advocate for in our own private lives, but I think when you're looking at a system of law and how it's applied to us as citizens and as people, neutrality is a producer of equality.
Yeah, I mean, I think the analogy to the marketplace of idea, or calling, free speech the marketplace of ideas, I think many people would agree that's a bit of a broken analogy at this point. In large part because for that to work, people have to actually engage with people who have different views than they do. And we, myself guilty, we're in silos, like we surround ourselves with the speech that we agree with and that we like. And it's very uncomfortable to go into a space and be exposed to ideas that you disagree with and find maybe even repulsive or abhorrent. Not to say that it doesn't work. I mean, there are situations where the power of free speech has changed people's minds and has shifted their ideology. An example would be, do y'all know the Westboro Baptist Church? It's kind of a cult church, and they have really anti-LGBTQ views, to put it mildly. I mean, they protest at the funerals of fallen veterans. They have, very hateful signs saying God hates fags, and armed services folks are dying overseas because, we allow gay people to be in the military, and they're kind of a fringe group, but they're, active, and their daughter, who was raised in that church, whose name is Megan Roper Phelps, right? Yes. The way she got out of that kind of cult church was through Twitter. She had access to Twitter, and she started engaging with people in a very real way on Twitter, and through communicating with them and exchanging ideas, she started to see, there is this world outside of this cult church that I've been raised in. And she eventually left the church, and she, has partnered with Fire to do this really amazing podcast series about J.K. Rowling's and all the sort of controversy around J.K. Rowling's, and anyway, what is it called? The trials.
The trial of J.K. Rowling,
yeah,
I think, yeah.
The witch trials of J.K.
Something
Rowling.
Like that, yeah.
But anyway, that Megan Ropes-Felper is an example of where free speech did change somebody's worldview. It did change her total ideology purely through engaging in dialogue. But that's rare. So It happens, but it's rare. But at the same time, we are also in an age where there's incredible access, much more so than there has been previously in history, where anybody with a cell phone and an internet connection can start news gathering and reporting, and maybe the world will see it, if it gets picked up. The online world of speech and video and photography has really expanded the potential marketplace. It's just that, as I said, people get into their silos and just hear what they want to hear. So
I have a question.
Yeah.
Let's open it up if anybody has questions. Yes, sir.
So you talked about encampments earlier. We actually had this UCLA, and you said that these universities are changing their policy to basically not allow that. Is that something that's objectionable? I mean, it seems like it's viewpoint biased. It seems like it's something that's reactionary towards a viewpoint that they don't agree with. We've seen something like with religion. It's pretty obvious that something like Hialeah. But how does that factor into something that's not necessarily religious based, that would potentially be objectionable?
Yeah, so with the Hialeah analogy, you're talking about animus toward a particular viewpoint, right? So, yeah, I mean, the answer is they can do it unless it's viewpoint based. And it's really easy to write a viewpoint neutral rule that says you shall not have an encampment on this college campus, right? It's really easy to say no gathering in this, area of land past, say, 9 p.m. or 10 p.m. or whatever, shall be allowed. There's actually a law that was passed in Texas that we're challenging, and we got a really great preliminary injunction where the court said, the First Amendment doesn't go to sleep on college campuses, at the hour of 10 p.m. or whatever, right? Now that's talking about like speech broadly, right, or protest activity. Setting up at camp and like sleeping outdoors is something that can permissibly be banned and has permissibly been banned by all sorts of like national parks and state parks for decades now. But if you have evidence that they're, crafting a facially viewpoint neutral rule or content neutral rule, but doing it because of an animus towards a particular viewpoint that has been expressed, the line starts to get a lot grayer really quickly, as your question suggests, right? It's a question of evidence. It's a question of intent of the rulemaker. If, as in the Hialeah case where you have so the city of Hialeah versus Church of Lakumi Babalu, if I remember correctly. Yeah, was about a city banning the ritual sacrifice of poultry to target Haitian immigrants. And in that case, you had lawmakers very stupidly making a lot of public statements about their intentions in banning that practice. Whereas if they had just kept their mouths shut and banned the practice, it would be really hard to prove that they had religious animus toward those immigrants. Oftentimes you'll find, we worked together in an ag case in North Carolina, where the lawmakers made a lot of stupid statements about animal rights activists and how we don't want these people coming into the state and recording stuff and harming our agricultural interests, right? And you can use that in litigation to show, no, they're targeting a very specific kind of speaker because of their viewpoint. So it all kind of comes down to evidence.
When you're litigating cases that are not nearly as popular in the court of public opinion, how do you deal with that both from in the courtroom but also in the court of opinion, kind of cutting through all of that noise to actually defend the First Amendment?
Mike, you have to repeat it. Yeah. So the question is about how you deal with cases that are in the court of opinion.
I'm sure you have experience with this.
The different challenges that those bring.
Yeah, we have a line we like to say at Fire: if it's protected, we'll defend it. No questions asked, no bones about it. We understand that some of our clients are going to be unpopular. It would be great if all of our clients were sympathetic and they said things that we all agree with, but then we wouldn't need the First Amendment, right? So the law exists in the way that it's developed through this jurisprudence precisely to defend people who speak unpopular sentiments and get in trouble for it. And that goes for speakers who identify as politically blue, and it goes for speakers who identify as politically red, and those political winds, shift, right? So I'll give you an example. In the state of Florida, the DeSantis administration passed the Stop Woke Act to try and stop professors from teaching so-called divisive concepts, right? Regardless of where you or I stand on that law, it's very clear that the DeSantis administration wants, is sincere in its belief that teaching, say, the history of race relations in America makes white students feel uncomfortable and guilty, and they want to stop that from happening, right? I think that's misguided. I think it's an affront to academic freedom, and so we're defending a professor who teaches the history of race relations in America, Professor Novoa, in our case challenging the constitutionality of the Stop Woke Act. The flip side of that coin is a case that we just brought and won in Seattle on behalf of a University of Washington professor who made a parody of land acknowledgement statements on his syllabus. Right? He's a conservative libertarian. He's in a blue state. He was encouraged to put a sort of reverential land acknowledgement statement. Excuse me. Yeah, so a land acknowledgement statement, it's less popular now on the East Coast, I think. It's been kind of spreading from the West Coast across the country in recent years. I think it started in areas where there's more of a native population remaining because of the spread of so-called manifest destiny across the country from the east to the west. The University of Washington's land acknowledgement statement says the University of Washington acknowledges the Coast Salish people of this land, the land which touches the shared waters of the Suquamish, Tulalip, and Muckleshoot nations. And so it's basically just supposed to acknowledge that there were people here before, there are people who are still here. We are a sort of white Western institution that occupies this land, right? And there was even a statement on the University of Washington's Office of Minority Affairs website that said, leaders recite this statement at the beginning of gatherings on campus to acknowledge that the university sits on occupied land. So there's this notion that there's something illegitimate about the presence of the university, and that illegitimacy is being recognized by the university itself, right? The university shied away from that occupied land statement in the litigation. They didn't actually take that position when it kind of counted, when they would be held accountable to it as a violation of academic freedom. But the professor in that case wrote a parody statement that said, I acknowledge that by the labor theory of property, the Coast Salish people can claim historical ownership of approximately none of the land currently occupied by the University of Washington. So he really touched the third rail, right? And he knew his parody statement would be offensive, and you say that statement to a room of people who are inclined, even primed, to disagree with him, and he looks like a complete asshole, right? And yet, the opinion that we got on neutral principles of academic freedom will redound to the benefit of every professor of a public university or college in the Ninth Circuit, which encompasses nearly the entire Western United States, regardless of the viewpoint that they express, whether they get in trouble because they work at a conservative campus or a liberal one, right? So that's the value of taking unpopular clients. That's the value of defending neutral principles, because we're building and contributing to the development of a system of law, right? Of these neutral rules that apply to us all, even when we say something unpopular.
And also, if I could add to that, the First Amendment doesn't mean very much if it just protects the speech that we think is good and helpful and we like it. Where it really means something is where it protects speech that is hated. And so, for us to fully sort of realize the value of the First Amendment, we've got to be defending the speech that we hate. It's fine to defend speech you like too, you can do both, but you can't be one-sided about it. And as Gabe was saying, a lot of these cases that arise out of so-called hate speech or hate groups, they create fabulous law. Wonderful language that you get to use when you are defending the causes that you believe in. You know, like the Brandenburg case about the Klan in the field that, you know, they were talking about overthrowing the government or, you know, violence based on race animus, but they weren't actually doing anything about it, so it wasn't incitement. That case gets cited over and over and over again to defend, you know, the Black Panthers, Black Lives Matter, all kinds of progressive groups that are also doing things that people want to call incitement. And we get to say, no, 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 look at Brandenburg, look what that said. This is not incitement. And so it's really helpful, even though it might arise out of a case that you don't personally have affinity for.
Say your question.
Okay, so Mr. Walters, I really appreciated your kind of guideline for how to protect and uphold free speech. Ms. Norris, my question is, what is your kind of advice for people like us who are students on protecting the freedom of the press? We kind of talked about it.
Yeah, so great question. I mean, I think just knowing what's going on is step one, and like, you know, following the news stories about First Amendment issues and press issues. There's just so many right now. Supporting local journalism, whether that's like actually engaging in it yourself, like being part of your college campus or campus media or local media, you know, donating to independent media, because it's a tough business right now. Like, it's hard to make a living being a journalist. But it's such valuable work. It's such needed work. It's really what we call sort of the, you know, the fourth, what is the phrase, the fourth?
Oh, the fourth estate.
The fourth estate, you know. It's like our democracy doesn't function without a free press. And so whether you want to be a journalist, give money to a journalist, thank a journalist, become a First Amendment lawyer and defend journalists. Those are some of the ways that you can support them.
Other questions?
Yes, ma'am.
So under like the First Amendment, where does government speech fall? Like, does that work as like an exception, or because I'm only asking because I'm looking at the case. I don't know if you're familiar with like Scare versus the city of Nashua, where the Scare citizens, there's like this citizen flagpole in front of the city hall, and the whole situation came in where Scares flew a flag for women's, protecting women's sports, I think. I might be remembering it wrong. And then the city took it down the next day due to like outrage from the citizens about like it being like a transphobic flag. And the Scare sued, and they claimed like, or the city claimed like government speech. I'm not explaining this case.
No, I understand exactly. We know what you mean.
Okay. So where does government speech really fall under, like, you know, the First Amendment?
Sure.
Okay, so the idea of government speech is that the government is a speaker and the government gets to have a viewpoint. It gets to articulate its own viewpoint. It just can't punish private citizens for also expressing their viewpoint that maybe the government doesn't agree with. Okay, but the problem with government speech is that it's like a slippery slope, because once you start recognizing government speech and recognizing the government can discriminate in its own speech, have a viewpoint, where does government speech stop? It's just like everywhere. So these flagpole cases, I know they've happened in, I think there was one in Boston.
Yeah, I'm trying to remember the name of the case. It went to the Supreme Court and it came out really good.
Yeah, so that was kind of a tricky issue because like the city or the government agency that had the flagpole had kind of opened it up as what you might call a public forum, where like anybody could get their flag on the pole, and the government wasn't saying we endorse that flag or that flag speaks for us. It was just like, this is a public forum, you can come and fly your flag. But then the government wanted to say, no, it looks like we're endorsing it, it's our speech, we can't be endorsing that. And reasonable minds could disagree, you know, was it a public forum or was it government speech? And I forget how the case came out.
Shurtleff. I just looked it up.
Okay.
The name of the case is Shurtleff versus City of Boston. You know it because you're reading this related case. So yeah, the question is, has the government established what's called a public forum for private speech, right? Is the government speaking for itself by flying these various flags, or is it creating a public forum for private speakers by allowing multiple groups to come in and fly their own flags? And it sounds like in the Nashua case, I'm not familiar with it, but just from your description, it sounds like they're creating a public forum for private speakers. And then to pull a flag down because of what's called a heckler's veto, right? People are offended, people get up in arms about it. Is a violation of content and viewpoint neutrality in those spaces. A flagpole with an application process is probably what's called a limited public forum. And in a limited public forum, there are two rules. The guidelines for whether to accept or to keep out speech have to be viewpoint neutral, and they have to be reasonable in light of the purpose of the forum. And reasonable means essentially they have to have some rational basis to them, and they have to be administrable. They have to be capable of what's called reasoned application by the people who enforce those rules, right? So it sounds like if you're pulling down a flag because somebody disagrees with what it says, that's obviously viewpoint-based in a limited public forum. It's helpful to think about the government wearing different hats in First Amendment jurisprudence, right? So public forum case law is about the government as property owner. The government also acts as regulator and legislator, right? And there's a different set of case law when the government is doing that. The government acts as educator, right? The government acts as employer. And when the government's acting as employer, obviously it's speaking for itself through the mouths of its employees. There's a different set of rules. In Shurtleff versus Boston, it was 9-0 for the group that wanted access to the flagpole. So it came out the right way from a First Amendment perspective. And Justice Alito wrote a great concurring opinion that cabins the government speech doctrine to be very narrowly defined, right? So when the government is speaking for itself, the First Amendment doesn't really have anything to do with that. The government's allowed to speak. But we can't allow the government speech doctrine to become the exception that swallows the rule of First Amendment law, generally speaking. So we see in our cases, you probably see it in your cases too, the government trying to make this expansive use of the government speech doctrine to justify its own censorial action. And so far we've been pretty successful at batting that back. But that kind of mission creep of the government speech doctrine is a real concern in the law right now.
And it's gotten a toehold in the Fifth Circuit, which is mostly Texas, in the book banning fight, because the Fifth Circuit said it's government speech what books are in the library, and the government gets to control its own speech and say it's not going to provide access to certain books, which is a split with some, I think it's the Eighth Circuit that went the other way and said, no, it's, it's not the government speaking, because there's no coherent message. If you think about all the books in the library and all the different perspectives and viewpoints that you can find in those books, you cannot figure out what the coherent speech of the government would be. But that's an ongoing conflict between two federal circuit courts that maybe at some point the Supreme Court would take up. But that's the sort of latest, or one of the latest places you see the government speech doctrine being asserted.
Regarding what Dr. Gregory said about the two limitations of the First Amendment, really stuck out to me was the role in which social media plays on the First Amendment, the way in which individuals and private agents are kind of given the ability to either limit or promote certain messages within the public sector beyond just the United States and sort of at an international level. I'm interested how y'all believe or what y'all's perspective is on the role of the First Amendment within these private.
They're private companies.
Yeah.
Therefore, there's no state action. Therefore, the First Amendment doesn't apply. However, the Supreme Court recently held, rightly, that these private companies have their own First Amendment rights in compiling and displaying the content that their users generate, akin to the editor of a newspaper, right? There are critics of social media companies who, some have suggested that they should be regulated as what's called common carriers, which means an all-comers policy, right? The companies themselves don't want that. because if they had to accept any speech, they'd quickly become a 4chan style cesspool, and they wouldn't be able to attract users because these are companies offering a product, right? And the speech we generate for them is one of their products. Also, our private data, of course, is one of their products that they sell to brokers, and they sell ads, right? They sell ad space to advertisers. So I think the doctrinal questions and the questions of whether social media is good or bad, or whether they have outsized influence, are two entirely separate discussions. When you stop at the recognition that these companies have their own rights, that is. That's where the doctrine comes into play. But beyond that point, we're talking about something very, very, very different. I would say generally the spread of social media and multiple platforms of social media is, in the abstract, a good thing for democracy because there are fewer gatekeepers than there were when media was more concentrated, and because it's more participatory. That said, there are unequal cost and benefit distributions in that private marketplace, which is essentially a platform for speech. Justice Kennedy in Packingham versus North Carolina said that social media is the modern town square. That's also an analogy. I think it's a fairly broken one. It's very clear from how we're all siloed, that we're not all living in the same town, right? We're not engaging with each other across lines of difference on social media. The content that we see and interact with is algorithmically determined based on our prior likes and views and time spent on various feeds, right? I'm not on Truth Social. I'm not on Twitter anymore. I'm on Blue Sky with a lot of law professors talking to each other about law professor stuff. You know what I mean? We all have our audiences and our echo chambers. That said, it's not really much of a First Amendment problem to me. I mean, there are people who, I just did a conference at the University of Richmond School of Law, and it was full of people who were proposing various regulatory schemes for how to tackle the big tech problem and to treat social media companies as if they're quasi-state actors. And it was such a frustrating conversation for me to have because on the first panel of the day, which I was on, all three panelists agreed these are private companies who have their own First Amendment rights to display content. And if you try and regulate how they display content, including by calling it addictive or like by trying to impose product liability upon them for so-called addictive features, really what you're doing is you're targeting speech, either directly or indirectly. And if you have a regulatory scheme that targets speech directly, you have to satisfy what's called strict scrutiny. You have to have a compelling government interest, and the way that you regulate has to be the least speech restrictive means of effectuating that interest, right? So you have to have a really strong and narrow fit between the means and the ends, and you have to have a compelling end. If you indirectly target speech, you also have to satisfy a pretty strict test. It's not strict scrutiny, but it's called intermediate scrutiny, where you have to have an important governmental interest and you have to have, I don't think it's rational basis. It's something higher than that. It's
almost rational basis. It's like.
But there has to be a fit between the means and the ends. A substantial relationship.
Yes.
Thank you.
It doesn't have to be the least restrictive.
Right.
Yeah.
Right. So it's really difficult, if not impossible, to come up with a way to rein in big tech that doesn't focus on the speech product, the expressive product that they're creating, right? And of course, that's what everybody wants to do. That's why they want to do it. So I'm not really sanguine on regulators' chances of doing what they want to do with respect to social media, and I think that's a good thing because I think the First Amendment does and should stop them from doing it. That said, I don't want my son on social media. I recognize there are social harms, and we can and should have real conversations about those harms. I think we should do it as a polity and a society, and we should take accountability for ourselves and our families and our, peer groups. And, if we see somebody falling down, a rabbit hole, we should try and deprogram them, like, Megan Roper Phelps, or there's this great guy, Daryl Dawkins, who goes around talking to Klan members, and he's collecting their robes, right? And, what he does is he just meets people where they are, and he says, hey, here's who I am, and they form friendships. They have regular meetups, and he actually takes the time and establishes the relationships necessary to try and address and redress, in some cases, the harms that are existing or that have been created in the past, and bring people around to his point of view and to like denounce the Klan. So we can and should have conversations about social ills and social harms, and we can and should gather in rooms like this and have difficult conversations about any number of things. It's not clear whether social media is the right place to do that, but we should be talking about social media as we should be talking about everything.
Yeah. You're gonna take one more question if there is one. No. Very quick. Okay. There's one more quick question. Anyone?
We chilled them.
Yes, sir.
Does the First Amendment protect foreign governments from spreading disinformation to us for like military purposes?
That's the TikTok case. So, I mean, the First Amendment doesn't apply outside of the United States, and it doesn't prohibit, in fact, it protects the right of people in the United States to receive propaganda from other countries. I mean, there's case law on that. So the place where you see this come into conflict is in like the national security interest area, which is why like the Supreme Court upheld the supposed TikTok ban, which never actually went into effect except for maybe 24 hours. Because, you know, national security is such a high, compelling interest, and the court said banning TikTok was like the best the government could do to sort of further that interest. But if you're, you know, outside of national security concerns in general, other countries are free to send propaganda into this country.
Yeah, I think the TikTok case came out entirely the wrong way, right?
Yeah, it was not a good First Amendment decision.
It was a travesty and just like at odds with 100 years of jurisprudence, nearly 100 years of jurisprudence, because it's a private platform for private speech, and you know, but more foundationally, I think there's a definitional problem and a who decides problem behind what is disinformation or misinformation or propaganda or whatever, right? Because ultimately you're talking about ideas. And although the First Amendment doesn't protect, you know, the rights of non-citizens speaking from foreign soil, Claire's right. It protects our ability to hear ideas. But there's the problem of, you know, take a couple of famous recent examples, right? It was disinformation or misinformation at one time that the COVID-19 virus leaked from the lab in Wuhan, where they were doing gain-of-function research on bat genetic material and viruses from bats that was funded by the United States. That was called disinformation. And the government leaned on social media companies to prevent that view from spreading, right? There were national security justifications for that, right? And now the view of this national security apparatus is that it's more likely than not that the lab leak theory of COVID-19's origins is true. The fact that Hunter Biden's laptop was found in a Delaware repair shop and that it had embarrassing material on it was considered disinformation or misinformation in the run-up to an election. And again, the government leaned on social media companies to prevent that story from spreading. And again, it turned out some part of that story was true. So there's real dangers in our ability, or in the government's ability, to label information as true or false, right? And alongside viewpoint neutrality is this central idea that the government should not be the arbiter of what is true.
On that note,
let's thank our speakers. Thank you.